And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in both Virginia and Texas. And we are here this morning on April the 24th of 2023 with all the legal news going on in your world so that you can be more, well, legally informed. We begin with the story of Kim Potter, who has just been released from prison this morning in relation to the shooting of Daunte Wright. You'll remember this case. This is the case of the Minnesota police officer who pulled out a gun instead of a taser at a roadside stop and was convicted in relation to that shooting and has just been released from prison this morning in relation to that. So that is something that is happening this morning. The former Minnesota police officer Kimberly Potter was released from prison after serving 16 months of a 2-year sentence in the shooting of Daunte Wright, who she shot in mistaking her gun for a taser during a traffic stop. Potter was released from the Minnesota prison at 4 a.m. this morning, noting the hour was due to safety concerns and issues of potential violence. Potter was convicted of 2 counts of manslaughter for the killing an unarmed black man during the 2021 traffic stop. Wright was pulled over for having expired tags and for hanging air freshener, but I believe also had warrants outstanding at the time as well. Potter will be released for supervised release in accordance with law, and that says that the officer has no plans to return to Minnesota and is planning on living in Wisconsin. Wright's mother, for her part, said that she was dreading Potter's release and is struggling to find peace. Some say I should forgive to be at peace, but how can I? I'm so angry. She's going to be able to watch her kids have kids and be able to touch them. I'm always scared I'm going to forget my son's voice. It gave me some sense of peace knowing she'd not be able to hold her sons. She has 2. I can't hold my son. She said Potter not being able to serve as a police officer again has given her a sense of peace. She'll never be able to hurt anyone as a police officer again. That's the only sense of peace I've gotten. And according to Potter, of course, she apologized, saying that she didn't want to hurt anybody. I was very distraught. I just shot someone. I'm sorry it happened, Potter cried as prosecutor asked her about her moments in relation to the shooting. The city of Brooklyn Center, for its part, agreed to pay a $3 million settlement in June of 2022. The Wright family says the payment has still not been distributed due to other unrelated legal disputes. So the settlement apparently is still frozen for whatever reason. They also said that the police center will undergo implicit bias training, and that training apparently has not yet occurred as well. So all kinds of things going on in relation to that case. In the last 18 months, the city has seen turnover in the police department and other city officers. The department has 42 sworn police officers on patrol. The city has also lost 6 out of 7 department directors, but was able to rehire. So apparently there's been some turnover in the jurisdiction relating to some of this as well. Thus, that is the end of this story about Kim Potter, at least for the moment. It seems Kim Potter convicted and now released from prison, having served the remainder of her time in a probation-like state with plans to move to Wisconsin in relation to all this. So, yeah, I'm still not sure why she didn't appeal her sentence, to be honest, because I think the criminal conviction was very shaky. She didn't really have the requisite intent or even the requisite recklessness, it seemed, based on the testimony that was available and even the judge's own remarks during sentencing. Everyone seemed to think of this as an accident. The judge used the word accident multiple times during the sentencing remarks and only used the word recklessness in respect to the actual formal legal definition, not in respect to Kim Potter's actions. So Trying to find the requisite mental state seemed very tricky at best, and the evidence didn't seem to really allow for that. So I'm not sure why she decided not to appeal. And but anyways, her time has been over. She's been released from prison, and that's, at least for the moment, the end of this story. All right. Thank you very much, everyone, for joining me today on Uncivil Law. You will see I have a blinking light in the background, which I need to fix because otherwise it's going to be really annoying on the edited video because I had a power outage. So I'm going to go do that right now so that it will stop blinking. I had a power outage just before the stream started, which is annoying because then my computer turned off and I lost all my tabs, which caused me to start late, which is annoying, but what can you do? What can you do but just press on? All right, hold on. I got to go fix my thing. Hold on. All right, I'll be right back. Oh, Lord. That time of day. It's 9:40 in the morning. Yeah. Great. Lord. All right, I'm back. Hold on. Did you miss me? Hello? Anyways, I've now fixed my clock behind me. That's exciting. The chili turned out very good, by the way. Thank you for asking. So, good times. Check 1, 2. Mic is still working. Great. Yes. Breathe. I will breathe. Breathing is good. All right. It's going to be a good day. You're digging the beard and stash. Thank you. Thank you. Appreciate that. Life happens. Just roll. You're right. I get frustrated when things don't work when I'm streaming because I want things to be good for you guys, right? And so when things don't work, when the technology fails, or when there's a problem, or for example, my lights have decided to not work properly and I had to manually set them, I get a little bit frustrated. You put 2 ounces of dark chocolate in your chili? That's an interesting idea. I could see that working. Yeah, I could see that potentially working. That's an interesting idea. I should have put the meat in before I put the Guinness in and get it a little bit more browned. By adding the liquid first, it prevented the meat from browning as well as it could have. So, could have been better. Also, there was much criticism and critique of both my knives and knife skills in the comments of the video, which I thought was interesting. Many people were critical that my knives were not sharp enough and that my knife technique was not good. You need to curl your fingers, they say. Your knife technique was bad. So a significant percentage of the comments were relating to my knife sharpness and my knife techniques, which I thought was interesting. So yeah. All right. Oh Lord. Good morning, uncivilians. And the chili worked out very, very well. Yeah, chili worked out very, very well. I put it on some rice yesterday. Had those little individual cups of rice, put it on some rice, put a little cheese on top. Great, man. Yeah. And I will make sure to buy some garlic powder next time at the grocery store. Yeah. So, yes. All right. So let's do a new story. No fingertips in the chili, please. But human meat is best meat. How best can I show my love? Except by sacrificing myself. That is the level of my love. All right. All right. Brand new out of the U.S. Supreme Court this morning. The U.S. Supreme Court has just agreed to hear a case that deals with whether or not public officials can block critics on social media. So this has been something that's been sort of percolating for a while. Different public officials have tried to block people on Twitter, for example. The president of the United States, Donald Trump, of course, tried to block people on Twitter. A lot of people on the left were very unhappy about it. But then people on the left have also blocked people on Twitter, including, incidentally, Alexandria Ocasio Cortez has been noted to occasionally block people on Twitter and stuff like that. And so the US Supreme Court this morning has granted review in cases that deal with this exact issue. Can public officials block critics on social media or not? All right, so let's learn a little bit more about this issue. The U.S. Supreme Court on Monday has agreed to hear a case dealing with the issue of whether the First Amendment bars government officials from blocking critics on Facebook and Twitter. The justices took up the appeal by two members of a school board from Southern California of a lower court ruling in favor of school parents who sued after being blocked from Facebook pages and Twitter accounts that were maintained by the officials. So this is a school board case, and the school board people blocked the parents from being able to comment on the Facebook page, and they sued. The lower court said, hey, you can't do that. You can't block them. And now we're going to the U.S. Supreme Court over the issue. The justices also took appeal from a Michigan man of the lower court ruling against him after he sued a city official who blocked him on Facebook following critical posts. So we have two different decisions. We have one from Southern California saying, hey, school officials, you can't block people. And one from Michigan saying, hey, city official, you can block people. So we have inconsistent decisions from two different places. And so the Supreme Court takes up both cases, and we're going to review it. At issue is whether public official social media activity can amount to governmental action that bound by the First Amendment. So is this governmental action? For starters, is a social media account run by a politician a governmental action? The justices faced similar issues in 2021 involving legal disputes over Donald Trump's efforts to block Twitter. The justices brought an end to that fight after Trump left office, deciding the case was moot. And then the lower court threw out its own ruling, incidentally. So the lower court decided, we're not so sure about that, and actually ruled against itself, which was pretty funny. The California case involves elected members of the Poway Unified School District. They blocked parents of 3 students at schools on Facebook and Twitter after the couple made hundreds of critical posts on issues such as race and handling of school finances. These parents sued in federal court claiming their free speech rights had been violated. The school board members each had public Facebook pages identifying them as governmental officials. The page was entitled T.J. Zane, Poway Unified School District Trustee, and included a picture of school district signage, which sounds like it's an official governmental thing, as opposed to a personal thing. O'Connor Radcliffe also had a public Twitter profile. On that account and Facebook page, she identified herself as president of the Board of Education and a link to her official email address. A federal judge ruled in favor of the parents. The San Francisco-based Ninth Circuit agreed, finding the school board members had presented their social media accounts as channels of official communication with the board. The Michigan case involves a Port Huron resident who was blocked by a city manager after posting criticism relating to COVID-19. That individual sued in federal court, claiming their rights were violated. The account in question was a public Facebook page that identified the person as a public figure, included a picture of him wearing the city manager's pin, and frequently included information about city programs and policies. A federal judge ruled in favor of the public official's account in that case. The Cincinnati Sixth Circuit agreed, finding the public servant had not been acting in his official capacity when he blocked the pages. So you can see you have two very, very similar situations with two different decisions. You have school board officials who, on their pages, seem to be identifying themselves by their official capacity, using official email addresses and so forth and so on. The Ninth Circuit says, okay, that is governmental action. And then in the Sixth Circuit, you have a very similar situation with a public city manager who identified himself in similarly public ways, but the Sixth Circuit goes the other way and says, no, this is not official action. So is this official action, or how do you define official action in the social media context? And can public officials block the people? Two inconsistent decisions, both on review. Thus, we have this brand new CERT grant, which just happened this morning. That's how up to date we are here on Uncivil Law. Brand new CERT grant from the U.S. Supreme Court, where they grant certiorari in two cases, a Ninth Circuit case and a Sixth Circuit case, which reached inconsistent decisions with each other. And the U.S. Supreme Court is now going to review the issue on whether or not social media accounts are governmental action, or I suppose when are they governmental action, if ever? And then, assuming they are governmental action, can one of the actions be to block accounts or block people on those accounts? Can you block people in that way? So that'll be interesting to see how the Supreme Court deals with that. The Supreme Court has previously allowed governmental actors to block particular means of communication. For example, people who are harassing on phone calls because they take up too many resources. Now, presumably, social media doesn't have that same problem, but there is at least some precedent for the idea that public officials might be able to block certain people from certain channels of communication. So we'll see how all that reads on the social media age. And at least for the moment, that brings us to the end of discussion of this story. Exciting. Brand new things. Brand new cases that are happening right before your eyes. Exciting and fun. You add meat first, then the onion, then seasoning. Yeah, that might have been a better call, Generous. That might have been a better call. It didn't turn out very spicy at all. So I'm definitely going to have to add some more Frank's Red Hot. But that's okay. You can always add spice. You can always add heat. So I'll add some more Frank's Red Hot and stir that and I'll be fine. Butterfly in the sky. I can move twice as high. Take a look in a book. Reading rainbow. All right. Oh, and I also appreciate that people like my chili song. I saw, was it in today's chat or was it in the comments for the cooking video? Someone said that their husband just sings the Soup Time song now, like randomly. So apparently I have wormed my way into someone's marriage, and now Soup Time is just something that the husband sings. This pleases me. Soup time is glorious time for you and me. You and me. Soup time is glorious time for you and me, baby. And And now we have chili time is glorious time for you and me. Chili time is glorious time for you and me. You and me. Red pepper flakes are a good call. And yes, I'm aware that Better Than Bouillon makes a chili base. Unfortunately, they don't have it at my store. So I'm going to have to go figure out where it is and hunt it down. All right. I've made deer chili before as well. Yeah. All right, let's learn a little bit more about disturbing things going on in our world. A man has allegedly sexually assaulted a DoorDash driver at gunpoint and then shot at family members who tried to save her. So things are not going great here in DoorDash land with all that. So, yeah, here is a picture of a man who has some nefarious intent with relation to the DoorDash driver who tried to help him out. Police claim the man kidnapped the DoorDash driver, sexually assaulted her, and then shot at her relatives, then robbed another woman hours later. Wow, that's a lot. Joseph Killens. His name is Killens. Joseph Killens, 38, is locked up in Florida. The criminal is now off the street thanks to tireless efforts of the Tampa Police Department. My thoughts remain with the victims. I hope this arrest brings them some sense of comfort. Wow. According to cops, the DoorDash driver had been making delivery when Killens forced her back into her car at 11 p.m. Family members tracked her down through her phone and saved her, though Killens managed to shoot a relative of the girlfriend. According to police, Killens forced the victims at gunpoint to drive to the Burla Lake Apartments, where he then sexually assaulted her. The victim's family had been tracking her phone, arrived and rescued her from the car. Killens responded by firing multiple times, with one shot striking a family member of the victim's girlfriend, a female in her 20s, before fleeing the scene. Officials then say Killens then robbed another woman early Wednesday. He allegedly threw her to the ground, punched her, and stole her backpack. Wow. So on a bit of a crime spree there. Yeah. Detectives say they tracked Killens down to the Tampa Inn. Killens is charged with armed kidnapping, robbery with a firearm, armed sexual battery, aggravated battery with a weapon, and also a separate robbery charge for the other attack. So a lot of things going on here in Florida. Thus, that brings us to the end of the story of Joseph Killens, who committed sexual assault and battery and kidnapping and aggravated assault with a firearm and probably attempted murder. And yeah, I don't know what the lesson here is exactly, but they got the guy and he's going to jail probably forever. And that, for the moment, brings us to the end discussion of this story. Yeah. So, yeah. Blackbird says Kim Potter was released from prison. Yes, I know. We covered it already. It was our first story out of the gate this morning. We are just that good over here on Uncivil Law. So, yes, we have covered Kim Potter being released. We also covered the Supreme Court granting a cert grant. Brand new law that's happening before ours. We are first out the gate here. Is he entitled to presumption of innocence? Yes. Of course, he's entitled to presumption of innocence. But, you know, it doesn't look real good. So sure, innocent until proven guilty, but you know, it doesn't look real good. You know? Uh, so yeah. All right. I mean, the victim is alive, and the family apparently found the victim with the suspect in the car because they he was shooting at them. So, uh, yeah. Did the person they shot survive? Apparently, yes. So yes, dog was barking and I missed the deets. Yeah. Well, all right. In cold case news, DNA from a coffee cup has linked a golfer to a decades old violent sexual assault case on courses in two different states. So some of these cold cases are becoming resolved now through DNA testing because DNA, wasn't available at the time. And some of this information was sitting around in databases. And sometimes, every once in a while, someone's DNA pops up and it's like, oh, yeah, we can clear out these old cases. So DNA has apparently resolved decades old sexual assault cases in two different states. Here, apparently, is a guy who committed sexual assault in golf cases in different jurisdictions. On September the 6th of 1999, a 22-year-old woman was working at a food stand at the Twin Lakes Golf Club in Michigan. An unknown male entered the employee only restricted area and apparently violently assaulted the young woman. The suspect took off but left DNA behind. DNA was uploaded to CODIS, but there was no match at the time. 9 months later, a 19-year-old woman was jogging near the 18th hole of Blue Course in Pennsylvania when she was approached by a man who had asked if she had a band-aid in new directions of the clubhouse. The young woman told the man she couldn't help him and tried to continue jogging, but the man held a knife to her throat and dragged her off. The woman told the police the man punched her and then sexually assaulted her. The suspect demanded the woman keep quiet and took off, leaving his DNA at the scene. In 2004, CODIS linked the DNA from the 1999 case to the 2000 rape case, but no specific match could be made. So these DNA is uploaded into the FBI database and it's just sitting around waiting for a match to happen. In two separate press statements last week, investigators confirmed that in 2021, Penn State Police Department began working with Oakland County to see if they could nail down suspects using advanced DNA technology. Detectives partnered with an organization which does next generation DNA mapping. Genealogy results narrowed down the DNA to three potential suspects, all of whom were brothers. So they did some genealogy related DNA testing and DNA matching and was able to narrow it down to three potential people. Then from there, they started investigating the individual brothers and narrowed it down to their suspect. At the time of the Michigan assault, court documents show that the individual that they think did it lived near the Twin Lakes golf course and was potentially visiting their brother who attempted Penn State. So they're like, okay, this is probably our guy. DNA extracted from a styrofoam coffee cup he'd been drinking out of did the match. So, excuse me. Okay. So once they were able to figure out who their guy was, they probably presumably followed him around until he disposed of something they could DNA test. He abandoned it. And so they did the DNA testing off this abandoned styrofoam cup. And it's like, okay, if that's a match. So now we know our guy. In Michigan, the individual's been charged with first and second degree felony criminal assault. In Pennsylvania, he'll be charged with felony counts of sexual assault and aggravated indecent assault. Oakland County Sheriff says that the individual involved is an avid golfer and has golfed around the country, and so potentially has assaulted other people in other jurisdictions. So now, presumably, his DNA might match other people in other places, or maybe based on MO or other factors, we can tie him to other places. So the investigation, in some senses, is only just beginning, but the charges against him are quite serious in multiple different jurisdictions. So I don't think it's going to end well for him in any case. Thus, that brings us to the end of the story of this guy who committed sexual assaults in at least two different golf courses, in 1999 and 2000, and probably other times too, one would imagine. And the DNA was in a database for a long time. And then as DNA testing got better and better, we were able to do genealogical testing that enabled us to narrow it down to the family line. And then from there, we were able to figure out probably which guy it is, and then able to collect DNA from a styrofoam cup to figure out, okay, this is our guy. And now he's arrested and facing charges in Michigan with charges in Pennsylvania, presumably soon to follow. And one would imagine charges in other jurisdictions as well, because it's probably not the only two times he assaulted a woman near a golf course. So, DNA testing coming to bring some of these people to account finally, which is justice at last. And that, for the moment, brings the end of discussion of this case. Warning: if your family member may be an SA perp, don't do testing. I don't know. If one of my family members gets popped from DNA testing I did, I'm not sure that's a bad outcome. But, you do you, I suppose. Maybe don't do the sexual assaults. That'd be the better lesson. You're being sarcastic? Fair enough. Sarcasm sometimes doesn't play well on chats. So, noted. All right. We turn our attention to Texas, where a habitual drunken driver has gotten a life sentence by a Texas jury after his ninth driving under the influence charge. So this guy has gotten convicted 9 times of driving under the influence, which, probably means he didn't drive drunk only 9 times. He was caught and convicted 9 times. And now a jury has sentenced him to life, which, since he didn't get the memo the first 8 times, yeah. Christopher Stanford, who is 50, was sentenced Tuesday by a jury in Parker County, Texas. He had pled guilty, but chose to have a jury decide his sentence, which is something you can do in Texas. So in Texas, that is an option. You can have a jury decide your sentence. And so he's like, I'm going to have a jury decide my sentence. I'm not sure how he thought that was going to end, but that's what he decided to do. It's like, I'll plead guilty and have a jury decide my sentence. Okay. The Parker County District Attorney said Stanford was treated as a habitual offender because he previously served 4 prison sentences for felony driving under the influence. This was his first DWI in Parker County, but had other convictions in other counties throughout Texas in the Dallas-Fort Worth area. The incident that earned the life sentence apparently began in August when law enforcement responded to an accident about 30 miles west of Fort Worth. Stanford had run a red light and rear-ended another car, whose driver told police that Stanford appeared to at least some awareness of the consequences. I have to go, Stanford reportedly told the driver. I'm going to get in trouble. Stanford then reportedly took off, jumping over a barbed wire fence. Police found him about 30 minutes later hiding in a bush, his jeans ripped and cuts on his body. Prosecutors described him as clearly drunk and belligerent and unable to stand without help. At one point, he even tried to headbutt the EMT that was trying to help him. He was so drunk and obnoxious that officers were unable to admit field sobriety tests, but, we were able to determine he was drunk through other methodology. His blood alcohol content, once tested, was 0.267. Wow. I mean, that's a little bit over the limit. 0.267. Wow. I mean, so yeah, a little bit DUI, just a little bit DUI. Wow. Swan, the district attorney, reportedly said that the individual who was arrested told jurors he was very unlucky, but he didn't believe he had any alcohol problems. I don't know, man. You don't think you have alcohol problems, but you have 0.267 in your blood, and this is your 9th driving under the influence. So, I think you might have some alcohol problems. I thought his testimony showed a lack of insight. I tend to agree. In our case, he was not just intoxicated, he was flat out drunk. With that level of intoxication and high speed, we're really lucky that the people he hit only suffered minor injuries. Jurors apparently took 90 minutes to decide his fate. He may be eligible for parole earlier. Under Texas law, Mr. Stanford will be eligible for parole when his actual time plus good time credit calculates 15 years. But any decision to release him will be made by the Texas Board of Pardons and Paroles. So he has to serve at least 15 years of time. And, given the 9th DUI thing, I don't know, man. Things are not looking great for him. Thus, that brings us to the end of the tale of Christopher Sanford, here seen in 4 different mugshots over the years, who apparently doesn't believe that he has an alcohol problem, despite the fact that he gets arrested a lot. He's just really unlucky in getting pulled over and arrested and convicted, and really unlucky with the 0.267 blood alcohol limit. He's really, really unlucky. The jury apparently thinks that life in prison sounds about right for our 50-year-old miscreant, because apparently he didn't get the memo the first 8 times and is obviously a danger to society. So, yeah. So that is the fate of Christopher Sanford, at least for a moment. That brings us to the end of discussion of this story. He'll go through serious detox in prison. Not his first time. Yeah. I'm sure he's got it figured out. All right. Let's do this one. Yeah, let's do this one. I'm not sure if this is a good story or not, but we'll give it a shot. All right. Is life common for something like this? No, it's very uncommon. Two 225 of you currently watching. Outstanding. Thank you for joining me here this morning on Civil Law. You guys make me feel good inside. You guys are my energy. You guys are awesome. And your support is so appreciated, especially on days where things don't go perfectly right technologically and you get a little frustrated because things are not going perfectly right. So thank you for all of you who are here. Just a friendly reminder, by the way, to remember to share this on your social media choice. There should be a little share button below your screen. You can share this on the Twitters or whatever. Help people learn about the things. Hit the like button. You can do those things. Help with the engagement. All right, let's try this story. The Arizona GOP has been ordered to pay legal fees in relation to a bad faith lawsuit that they filed regarding challenges to the election. So, some of the elections lawsuits that were filed were kind of garbage, and they were kind of garbage at the time they were filed. Some of them were filed in a zone of uncertainty, so not all of them were this bad, but some of them were this bad. Some of them, there was no basis at the time for some of it, and people kept persisting even after information came out that there was no basis for it. So they have to pay costs in relation to this lawsuit. An Arizona appellate court ruled that the Arizona Republican Party must pay attorney's fees for the Secretary of State in a lawsuit relating to Maricopa County ballots. The lawsuit challenged procedures for post-election hand counts on grounds that county's use of a vote center model instead of voting precinct meant that the audit that was conducted was illegal. But the trial judge says the case was without merit because it was groundless and brought in bad faith and little more than an attempt to undermine the election. So it's like, no, this isn't actually a real lawsuit. You are doing something frivolous. You know you're doing something frivolous, and you can't do that. That is not something you can do. So the Arizona Court of Appeals upheld the ruling that the Republican Party must pay about $20,000 to the Secretary of State's office and also require them to pay for the cost of the appeal. So, yeah, not a huge amount of money, but you have to pay costs for the legal fees. The Arizona GOP was represented by Phoenix attorneys and Lee Miller, a former Assistant Secretary of State. It's unclear if they'll appeal it further, but they should just pay the money. They said, "We were surprised by the court's decision and will be speaking with legal counsel to discuss the best path forward." Thank you, Megan, for the gift memberships as always. Appreciate those gift memberships. Thank you. The lawsuit was filed more than a week after the 2020 election and argued that state law requiring limited post-election hand counts audits conflicted with the state's election procedurals manual, making it illegal for select ballots from audits for voting centers instead by precinct. The Maricopa judge dismantled the legal arguments that the Arizona GOP had made. In addition to ignoring the law and the legislature intent, which does allow for voting centers, they said that the Republican Party sought a remedy the law didn't allow for and waited too long to bring the lawsuit. The judge also said the party demonstrated was not motivated by some sincere challenges, but instead to make a political case and sow distrust. The judge said the most telling fact may be that it sued to block Maricopa County elections canvass after the hand count showed a perfect match with machine counts of ballots, writing it would create a cloud of legitimacy. So the hand count was perfect, respective to the machines. And it's like, no. This is why the court raised challenge as whether the plaintiff brought suit in order to cast a false shadow, undercutting the election by raising questions, is what the plaintiff did in this particular case. The three-judge appellate panel unanimously ruled as well, writing that the Arizona GOP first sought to challenge the hand count, but then dropped in an order to block Maricopa County from certifying elections, which betrayed the true purpose of the lawsuit. What do I think about you sending me stories? You can send me stories. That's cool. If there's good stuff, I'll be happy to try to cover it. I always like when people send me stuff. That's nice. All right. You missed the kicking show? Well, you can always watch it back, and you too can critique my knifing skills. Thus, that brings us to the end of discussion about this case in which the Arizona GOP has to pay the Secretary of State of Arizona legal costs in relation to what the courts have determined was a completely knowingly frivolous bad faith lawsuit. And, there were unfortunately several of these kinds of lawsuits. Not all the lawsuits that were filed were knowingly frivolous, but some of them were. And this is one of them. And the GOP has made themselves look a little bit bad by fighting some of this frivolous stuff because it has a tendency of dragging everything else down. When some of it is just absolutely totally frivolous, anything that does even look a little bit legitimate is that much easier to just say is also frivolous. It's the rotten apple spoils the whole bunch problem. So by bringing bad claims, it has a tendency of making any good claims that do exist look worse by comparison. It's easier to write them all off as all frivolous. So some bad faith lawsuits that creates problems for the GOP and certainly making any arguments about the election and any sort of legitimate claims that they might have had. At least for a moment, that brings us to the end of discussion of this story. Judge jailing a soft set for a year should deserve it. Soup time is glorious time for you and me, baby. Soup time is glorious time for you and me. All right. Well, we have some Florida man stories, neither of which is fun, though. Just noticing nice shirt. Well, thank you. Try to keep things looking nice. For all you guys, trying to make things look nice and lovely. Trying out a new toothpaste as well. Is my smile brighter? Am I cooking for us next week? I don't know. We'll see. We'll see. All right. Let's do this story. Yeah, Lord. Today's Florida man comes courtesy of Walt Disney World. As a cast member, an employee of Walt Disney World, has been arrested for repeatedly recording upskirt videos of guests at Walt Disney World. So, yeah, that happened. The Walt Disney World cast member has been charged with video voyeurism after caught filming under a visitor's dress at Disney World Hollywood Studios. It wasn't the first time the individual had secretly filmed women at the theme parks, you don't say. He has admitted to recording video footage looking up strangers' skirts and dresses for the past 6 years at Disney. 6 years he's been doing this. He estimated he had over 500 videos on his phone. He takes them because apparently it's hard to find the right content online, and he brings them home for his self-pleasure. Ugh. He apparently willingly showed some of the footage to law enforcement on his phone during his being arrested. The videos appear to depict multiple females, all of whom appear to not know they're being video recorded. What finally ended all this was him getting caught on March the 31st. Diaz had been working at a retail shop located in Star Wars Galaxy Edge at Disney's Hollywood Studios. Apparently, the instant in which he got caught, he was filming an 18-year-old woman wearing a black dress with black shorts underneath, who was shopping for lightsabers with her fiance, as well as other women. When another cast member apparently noticed what was happening, the 18-year-old woman, for her part, said that she had no idea she was being filmed at the store. Wow. Diaz told authorities he'd been diagnosed with some sort of condition and faces third-degree felony charge of video voyeurism. He is apparently not the first person to be caught doing this as a cast member. In 2018, a different Walt Disney World cast member was caught using a cell phone in employee-only men's bathroom at Disney's Animal Kingdom and charged with video voyeurism. So that individual pled guilty to video voyeurism after he took pictures of girls between ages 4 and 7 while vacationing at the Magic Kingdom. Let me redo that line. A third individual, who was a Chinese national, also has pled guilty to video voyeurism in 2014 after that individual took pictures of girls between the ages of 4 and 7 while vacationing at Walt Disney World. So, yeah. Thus, that brings us to the end of the story. Well, let me do it this way. No. There we go. Thus, that brings us to the end of the story of the Walt Disney World cast member who apparently for several years has been video voyeuring many women's at the Disneys, several hundred of them, without their knowledge, and finally got caught to all that. So, yeah. So has been charged with third-degree video voyeurism, and I imagine other charges will be coming as this is all ongoing. And, when we do a search of his computer, what else might we find on his computer, I imagine? Because what other kinds of videos might he be into? So I would imagine the charges are just starting to come down the pipe for this guy. And that, for the moment, brings us to the end of discussion of this story. Yeah. 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 Then I have Florida man shooting at an Instacart person who drove into the wrong driveway. Well, I don't know if I want to cover that right now. So, yeah. Well, I guess that will bring us to the end of today's stories, which fortunately we were able to do a stream today, so that's nice. So, yeah. Some basic laws should be covered in school. I don't really think that this is a lack of education problem. I don't think there's a lot of people who think that, doing upskirt videos is lawful. I'm not, I'm not sure we need that lesson. Maybe don't surreptitiously record women's who you don't know. That shouldn't do that. The chili turned out great. Thank you for asking. You know, I'm not sure this is a legal education problem. Am I going to visit Ian and Canada? I might. Excuse me. Tip time is glorious time for you and me. You and me. Soup time is glorious time for you and me, baby. Don't you forget to put garlic on my shopping list. A good woman would have an ongoing shopping list. I know. I need a good woman for shopping lists and other things. Need to sell my song to Campbell's for millions. Sing the news, like auto tune the news, old school like that. Auto tune the news. All right, guys. I guess that'll do us for today. I've enjoyed the stream. I hope you've enjoyed the stream too. Again, apologies for the slight delay due to the power outage issues that happened just before the stream started, which was annoying. I need to add a uninterruptible power supply, I think, to my list of things. So hopefully that will not be a problem for little brief outages like that. So yeah. So I need to add that to my list of items I need. But that's another problem for another day. If you're enjoying this, please remember to subscribe, do all the YouTubey things. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.